If you could start the amazing. All right, thank you so much. All right, thank you everyone, and welcome to this public legal education session on family status accommodation. My name is Richa Sandill. I am an employment lawyer at a legal aid funded clinic called Don Valley Community Legal Services. I am joined by my co-presenters, Tisha Alam, who is also an employment lawyer and in fact, the team lead for employment law at Scarborough Community Legal Services, and Regini David, who is a law reform outreach coordinator, as well as a paralegal practicing in employment law at West Scarborough Community Legal Services. I wouldn't be surprised if many of you heard about this event due to her incredible prowess in being out there in the community and doing so much outreach in Scarborough. We're really thrilled that you can join us this morning. For those of you that aren't familiar with the clinics, we are essentially community legal clinics that are funded by Legal Aid Ontario to provide free legal advice, representation, and services to low-income members of the communities that fall within each of our catchment areas. There's many of us across the province. On this session today, 3 are represented that provide services to areas like East York, Thorncliffe Park, West Scarborough, Scarborough east of Midland Avenue. And our goal in our work isn't just to provide your standard legal lawyer services that you would imagine, but also try and get our community engaged in law reform and issues that matter to them that affect their lives, as well as provide legal education on important topics like this, so that our communities that we serve are better informed about their rights. We put this session together in that spirit, and particularly in recognition of the many parents and caregivers, particularly of young children, who, for lack of a better word, have been the most squeezed during this pandemic. Not just because they're balancing work, but they're also balancing childcare, which in and of itself is always challenging, but they've had to do so amidst mass shutdowns of schools. And I think, one of the things that we really want to emphasize is the fact that you don't necessarily have to do it all, that if in the midst of this, you feel that you need to ask your employer for help, for accommodation, a lot of people don't realize that that ask is not a favor. It's an enshrined right that you have under legislation and under a lot of case law that's developed over particularly over the last 10 years. So we wanted to give you some more information about those rights. We're also going to be talking about sort of practical applications of how to ask for that accommodation if that's something that you need. And then we'll be also going over sort of joining the movement in terms of areas in which we and the clinics are out there advocating for reform in aspects of the law that affect family status. And encouraging you to get involved in doing the same. So I'll be going through the law, Tisha will be giving you your everyday tips, and then Reggie will be going over the law reform. There will be time for questions at the end, so feel free to get involved. We're going to ask that you keep your mics muted until the Q&A session. And if there's something that comes up in your head, as we're talking, please type it into the chat, but we'll take a look at it at the very end so that we can go through everyone's questions. And with that, since we are legal professionals, I'm also going to just start off by giving a quick disclaimer that even though we're going to be sharing a lot of information about the law, about your rights, please do not take any of the information that we're about to talk about as legal advice. It's not to be treated in that way. We're strictly trying to provide legal information and education. But if you have specific questions or need specific advice tailored to your situation, we'll provide the contact information for our clinics at the end of our presentation. You're welcome to give one of our intake lines a call and ask for that advice. So with that, let's get started by going through the law itself. So I don't know how many of you are familiar with the Human Rights Code and its provisions. It's a very important piece of legislation in the province. And I'm going to start off by going through its basic provisions so that you can have an understanding of how it works and where this concept of family status accommodation that we're talking about, accommodation for childcare needs, or if, depending on your situation, elder care needs, where does that come from? Because that's situated in Ontario's Human Rights Code. The Human Rights Code is quasi-constitutional legislation. That's a lot of legalese for basically saying that this is a piece of legislation in the province that has very high standing, particularly given the values of equality and freedom from discrimination, i.e. adverse treatment, on the basis of having a specific individual characteristic listed in the code as protected. And because it emanates, the Human Rights Code emanates these values, it's provided with a lot of deference. A lot of laws are interpreted in accordance with its values. Of course, the code does not apply to every single aspect or interaction of life that we have. I think that's important to understand. The code is limited to interactions that we have with people, with organizations in 5 areas of our lives, one of which is employment. And that forms a big part of the case law that has actually evolved out of the Human Rights Code. The Human Rights Code, because of its status and because it's applicable to employment, is implied and a part of every single employment relationship. So every employer has to abide by the duty to not just discriminate against someone, but also to maintain a workplace that's free of any kind of discrimination, that's free of any kind of violation of your right to be free from negative treatment on the basis of a protected ground, as we'll go through in a couple of slides, what they are. And this idea of discrimination being adverse treatment on the basis of a protected ground is just the starting point to the rights that come from the Human Rights Code, because it also includes a further positive duty that employers actually have to take steps to accommodate needs that come from somebody having a specific special protected characteristic. So the duty to accommodate, that's going to be something that's going to be coming up throughout the presentation. Just keep that in mind if that's a concept that you haven't come across before. There are, in addition, other provisions in the Human Rights Code that prohibit harassment against somebody for having a protected characteristic, i.e. being subject to a course of vexatious or unfair treatment on the basis of you, I don't know, having childcare needs or being a person with disabilities or being a woman or of a specific gender identity. And there's also further protections against reprisal, i.e. protections against you being punished as an employee for raising or enforcing your rights in the Human Rights Code. So that's also prohibited, as well as harassment and as well as the concept of discrimination itself. Another quick note, just that I've mentioned that this is provincial legislation, the Ontario Human Rights Code. That means that it applies to those workplaces that are regulated by the provincial legislature, so provincial governments. Most employees in Ontario work for provincially regulated employment industries. There are some industries that are actually under the purview of the federal government. So if you work in a bank, if you work in a telecommunications provider, if you work in a railway, etc., something that crosses provincial boundaries. So in that case, the Human Rights Code of Ontario is not applicable to you, but you are still governed by the Canadian Human Rights Act. We won't be covering that in this presentation as much, just because we want to focus on the code, but that's also something for you to be aware of, because a number of people do work in these industries. The Human Rights Act has similar principles. Each province has some form of a Human Rights Act or code. So that's something to just be aware of in terms of where to look for your rights if you're somebody who's out of province, although I'm sure most of you who are here today are from Toronto or the surrounding areas, or alternatively, if you work in one of those industries. And why I'm emphasizing a lot of this is also to help you understand that there are mechanisms available in the code as well to help you enforce your rights should there be a violation of the code, be it by your employer or by one of the other groups or entities that are covered by the code, like in a contract or goods and services provider. And that is that you have the right to make a complaint to the Human Rights Tribunal if you feel that your rights have been violated. You must do so within 1 year of the last date of whatever incidents you are saying occurred that violated your rights. So that's very important. There's a 1 year, very strict timeline on that. But ultimately, that is something that's available to you. And in that complaint, you can ask for a whole bunch of different remedies. You can ask for damages, you can ask for lost wages if you lose your job or lose out on specific income. I've seen the tribunal awarding lost EI benefits in cases where pregnant employees were dismissed, for example, and they lost out on EI benefits as a result of not having enough insurable hours. You can ask for non-monetary remedies like forcing your employer to undergo training, etc. So all that goes to say is there is a pretty robust scheme of human rights in place in the legislation that comes from the Human Rights Code. Another important concept to understand when we're talking about this duty to accommodate, because that's the road that we're going to be going down a bit further in this presentation, is the concept of undue hardship. So employers have a duty to accommodate, but up to what point? That point in law is known as undue hardship. That's the standard at which an employer can be able to say, okay, no, it's too much for me to accommodate this person. They're asking for me to make some kind of a special exemption, but I'm actually unable to do so because it's too much, right? For your understanding, what you need to realize is that undue hardship to get to that standard of an employer saying, no, I can't do it, is a very high standard. It's not simply, it's going to be expensive, or it's too difficult, or, oh, it's going to be inconvenient. I'm going to have to rearrange some schedules. I don't really want to say yes to you leaving an hour early to pick up your kid, right? Because I don't want to. I don't want to have to accommodate your personal circumstances, right? No, that's not what the law expects. The law expects that the employer will in fact incur some kind of cost or difficulty or inconvenience in accommodating you, right? That's to be expected. Where it's actually going to be undue hardship is if it's shown that your accommodation request will create a significant health and safety risk for the employer in the workplace, right? Where your request essentially means that the employer is creating a new job for you, or alternatively, it's so expensive that the costs will lead the employer to go out of business, essentially, right? And obviously, this is always assessed on a case-by-case scenario, but that's just to drive home the point that your employer can't just say, oh, it's too tough, I don't want to do it, right? Because that's not what the law expects. The law expects that you're going to be accommodated up to the standard of undue hardship. I was mentioning that discrimination is applicable if you've suffered adverse treatment on the basis of a number of protected grounds. These are the protected grounds that are listed in the code as bases on which people can't be discriminated against. Out of those, you'll see we've highlighted family status. That's what the focus of what we're talking about is today, now that we have an understanding of how the Human Rights Code and its protections work. So you have the right to be free from discrimination on the basis of family status. What is that? Well, Section 10.1 of the code, as well as a lot of case law that's come out of that, and a lot of the cases that have been decided on this point, have made it clear that family status means the status of being in a parent-child relationship. So you have the right to be free from discrimination on the basis of being a mom or a dad, right? Or a caregiver for an elderly parent, because both childcare and elder care accommodations or childcare and elder care needs are covered by family status. But you also have the right to be free from discrimination for having any kinds of needs that arise out of being in family status. So the simplest examples are some of the things that I've listed on this slide, right? So if you have a specific need that comes from picking up your child early, or needing modified schedules so that somebody can be home to care for the kids because there's going to be nobody else home in the evening, or if you need to leave to care for a sick child, all of those things might be obligations as a caregiver, as a parent, that you would have arising from being in family status. So because of that, part and parcel is that employers have the duty, like they do under any other protected ground, to accommodate you for your needs that come up from the this human rights protected ground, right? Again, these are some examples that we've seen in the case law. Different parents have different needs. I think an important distinction to draw here is that the protection for accommodation for childcare needs covers things that are actually arising and flow from the parent-child relationship as almost not necessarily legal responsibility, but something that you actually genuinely must do. It doesn't cover preferences, right? So it doesn't cover like needing to go to a dance recital and so you want to leave work early, or taking a vacation with their child, no. But if you need to be there to care for them, right? If you need to be at home or be somewhere to make sure that they're supervised because they're constantly under supervised care, that's something that could be reasonably argued as flowing from the status of being in a parent-child relationship, and that's covered by the code and its protections. There have been several cases, like I said, in the last 10 years that have really developed the law. Again, many of you might not be familiar with cases, so I'm not trying to bore you with legalese, but it's more so to help you understand that there is a lot of past precedent to go according to make any arguments or make draw sort of practical tips from, right? And it also shows, especially with the development that we're seeing in the law, that the tribunals and the courts are really trying to expand this issue and take it more seriously. All the cases that are listed on the screen have been from 2012 onwards. So this is an evolving issue. And that's also a big part of why we really want to get out there and be providing education and want people to know more about their rights and why it's important for people to understand this. So Missadich and Value Village is a very important case that came out of the Human Rights Tribunal. So it involved elder care. It didn't involve child care, but its principles are fairly similar. And it basically talked about sort of some of the steps and processes that you have to undertake as a caregiver in order to establish that you have in order to establish that you have genuine care accommodation needs, right? So Missadich was very clear that you need to establish that something that your employer is doing or a rule that they've imposed that's required you to take accommodation has caused real disadvantage to the parent-child relationship. So it's getting in the way of you being able to it's getting in the way of you being able to fulfill your parent-child responsibilities under that relationship. And then it's getting family status accommodation cases at the tribunal are going to be assessed on a case-by-case basis. And a big part of it is also that, like I was saying, you're not entitled to accommodation for preferences, but you are entitled to accommodation for things that are genuinely flow from your obligations of being in a parent-child relationship. And a big part of this is also that you have a duty to be cooperative as an employee in the process of accommodation. So if your employer is asking you for information, for documentation that's reasonable in the circumstances, you under the law have an obligation to cooperate. You don't need to give them medical diagnostic information if that's something that they're asking for, but you do need to give them information that's reasonable to help them implement accommodation. These are some other cases beyond Missadich that have expanded on these principles, but have also seen employees getting pretty significant damage awards in the event that an employer breached their rights to be accommodated and free from discrimination in the workplace on the basis of family status. So the Kovintharajah case was actually our case. So I represented the applicant on this one. And this involved a father who had an accommodation in place to leave an hour early so that he could meet his wife at home. His wife could go to work in the evening, and then he'd be at home to care for their 3 children and their 2 elderly grandparents. Suddenly the employer revoked that, refused to engage in any kind of discussion on accommodating him, threw their hands up and started disciplining him, and then eventually fired him for leaving work early. So because he still had those needs, right? So the tribunal was not happy about that. He was awarded a significant amount of damages in the end, right? Similarly to Devaney and ZRV Holdings. This involved a case of discrimination where an architect who was the sole caregiver for his elderly mother was suddenly stopped from working from home as he had previously been, and subject to a neutral rule that applied to everybody, which said, oh, everybody in the workplace needs to come in and show FaceTime. And when he was unable to because he needed to be home to care for his mom constantly, he was let go. Again, Partridge and Botany Dental. So a dental hygienist whose schedule was changed when she needed more flexibility to care for her kids. She also, this turned into a wrongful dismissal case, but she also managed to successfully challenge that employer's decision and was awarded damages of about $20,000. I'm not saying this to say that, damages are huge and, start going like suing your employers or anything like that. I'm only trying to drive home the point that these are rights that are increasingly recognized and protected in the case law and the code, right? And it is something that you do have grounds to take seriously and not just struggle and sort of try and fend for yourself when trying to manage and balance both childcare and work responsibilities. There is a lot of room in the law for development still, but this is something that we're seeing a lot more decisions and a lot more cases on. Other not human rights code related protections, but things that might also assist you if you are a parent or caregiver. Excuse me. So one is that the Employment Standards Act, which is minimum employment standards legislation that exists in Ontario to protect employees, provides a number of unpaid job protected leaves in case you need to be off work to care for a seriously ill or critically ill child. And this is on top of the protections that you have in general, that if you needed to be accommodated in the workplace for a leave, your employer, they don't have to pay you, but they would have to take that request for into account and see how they can fit it in and accommodate you. There's an infectious disease emergency leave that during the pandemic was enacted. It provides for job protected leave if you're affected by COVID, if you've been exposed to COVID. So if your child's been exposed to COVID, for example, and needs to stay at home, and by default, therefore, you've also been exposed, then you have the right to take infectious disease emergency leave. Up to 3 of those days are actually paid. And then there's no limit on the number of days that you can take after that that are unpaid. But that's a job protected leave that's been enacted during COVID times. There's special EI benefits available to cover the cost of any leaves that you might have to take to care for a critically ill or seriously ill child, and then such as family caregiver benefits or compassionate care benefits. And then there's also a federal government benefit currently that just got extended to May 2022. But basically, it's a federal benefit available if you need to be home to care for a child or somebody in your family who needs supervised care as a result of daycare, school, or regular facility closures. So the EI benefits that are available are generally available if somebody's sick, but this is in that situation where I know you need to take an infectious disease emergency leave, or school's been shut down or something, and because of COVID, and you're left without income. So that's a federal benefit that is available to caregivers as well. So these are some do's and don'ts, I guess, for the accommodation process that stem from some of the cases that I just went through. I'm not going to go through all of them. I think the one that I'm going to emphasize the most is communication. So disclosing your needs to your employer is important. Don't expect your employer to just assume and know, right? They have a duty to inquire if they have reasonable belief that you have some kind of needs that need to be accommodated under the code. But I mean, beyond that, I think what you need to realize is that it's your job to cooperate with them. It's your job to make disclosures if you need something accommodated, and it's your job to cooperate and provide more information. The Masadish case that I talked about was unsuccessful because the employee had actually refused to give proper information relating to her mother's care schedules, right? So this is very important. And the biggest thing is, like I said, don't expect your preferred form of accommodation. It's the employer's job to assess. They're supposed to go into a process and collaborate with you to figure out what works, right, for everybody involved, but you're not allowed to insist on your specific form of, oh, I'm only going to leave at 3 o'clock and it's my way or the highway. That derails accommodation processes, as Tisha's going to go through in a second. But that's also something that comes out of the law to be aware of, is you're not entitled to your preferred form of accommodation, but you are definitely entitled to accommodation. So speak up if you do need it. So with that, I am going to turn it over to Tisha now to take all the legal jargon that I just threw at you and apply that in a more cohesive and coherent form. So take it away.
Thank you, Richa, for that wonderful legal jargon. It's actually very valuable information. And I also just want to jump in and say that the work Richa did on the Kovintharajah case was what we lawyers call as precedent setting. It was one of the highest, if not highest, monetary awards for family status discrimination in Ontario. And it basically set a new standard for what claimants can expect to receive in similar circumstances. So before I jump in with my little practical how-to guide, a little bit about me. In addition to being an employment lawyer, I'm also a mom of a 2-year-old and a 6-year-old. So as a result, I'm not only the advice giver when it comes to how to request accommodations, but I also have quite a bit of experience in requesting them myself. So let's go through the little guide. So we'll go to the next slide. So asking for accommodations. When requesting accommodations, I recommend to always put it in writing. It's a good general practice. It keeps things professional. And in the event you need to refer to your request in the future, like if there's a misunderstanding, you can always go back to it. Also, you know your employer the best. Some employers are already aware of their code obligations. So all you may need to do is just send them a little request. In our experience, we find that employers usually fall into 3 different categories. So there's some who are sophisticated. They may even have like an HR or an office manager. They know what their obligations are under the code. Some employers might need a little, nudge or a reminder about what their code obligations are. And then there's also a third situation where your manager or your HR or your employer may already be aware that you need accommodations before you even ask, because they're either a witness to your daily struggle or because you've spoken to them about it conversationally. So even in those cases where your employer is aware and maybe they empathize with your situation, you still want to send a request formally to them, because as I said, it's always good to keep a record, especially if your manager changes. You may have an informal understanding, but if your manager changes, you want something on record about what your accommodation actually is. As Richa said, when making requests, just a general tip is to be clear and concise. Try to strike a positive tone if you can. If you can't, go for factual. What you don't want to do is be dramatic, combative, or negative. Just one tip I always have is when you're putting something in writing, in the event that your accommodation request doesn't work out and there needs to be a human rights claim, these emails can be used as evidence. So just think to yourself, what would a judge think? What would an outsider think if they were reading these emails? And try to write your emails or your written correspondence in that tone, keeping that in mind. So going to the next slide, we'll look at two examples. So the first example is an actual accommodation request that we helped someone make. So in this request, the person writes to their employer, hi employer, I'm writing to request a modified start time. So they say what the start time they want, 8 to 4. This would be a switch from a 9 to 5 schedule. And then they list the different reasons for why they need this modified start time. So the first reason being is that they have a long commute into the office. And then the second reason being that, or part of that long commute also is that in the winter, it becomes even longer because of inclement weather conditions. And then there's a second point, which is that this long commute, especially in the winter, affects the ability to drop this person's son off to daycare in the morning because they can no longer, drop them off and then try to get into work by 9 if it's a snowy day or an icy day. And then it states that if there's an earlier start time that's given, then this person can switch their daycare responsibilities with their spouse. They also then state that the request would be temporary until the end of February. So one thing that I just want to quickly highlight is when making an accommodation request, you kind of want to keep in mind that dodge of who, what, when, where, why. Maybe not so much the, where or when, but definitely the who and why and what, right? Like you want to state what your need is as someone who falls under family status. Maybe you're in a dual parent household, maybe you're in a single parent household, or maybe you're someone who takes care of their parents. You want to state, at the outset what your situation is to trigger that protected ground. Then you want to state why you're requesting that accommodation, which has been done here through those details. And then you want to request also at some point what form of accommodation you're requesting. It doesn't necessarily matter in what order, it's whatever works best for your situation, but it's just good to keep those who, what, when, where, whys in mind when you are making those requests. Okay, and then the next slide. So with accommodation requests, don't be put off if after you've made the request, your employer comes back with a request for more information. Maybe they don't say to you right away if they're going to give you the request or not. Do not be put off by that. Try to assess what information your employer is requesting. In many cases, the information may be something that your employer needs in order to give you that accommodation or to verify that you indeed need an accommodation. So if you find that the information they're requesting is not reasonable, then it's a good idea to seek legal advice. But if it is something that strikes you as being reasonable, then you make your best efforts to try to provide that information to them. So going back to that previous real life example, in that case, the employer came back to the person who was requesting to change their shift schedule, and they asked for a policy about the daycare's hours of operation. And then the person sent a link to the daycare's operating hours. And in this case, the person was able to get that accommodation. So now we will move to our second example. So that first example that I gave you was a informal accommodation request. If you looked at the words carefully, you would have noticed that nowhere in that original request was the word accommodation actually used. It was just a request to change the shift times because of certain reasons. In some cases, though, you may need to make a more formal accommodation request. So and I know, sorry, these words are like really condensed on the screen right now, but in this request, this was a request made by somebody who had verbally requested an accommodation from their employer a few times, and the employer didn't respond to them. So then we recommended to them that they send a more formal letter, basically triggering those code protected grounds and asking for their request and referring to those previous requests that they had also made. So when making a more formal request, these are some tips you may generally want to follow. You want to, if it's an email, it'll already be date stamped. So you don't necessarily need to put the date, but you do maybe want to put who you're sending this to. So like you would as if you were sending a letter. So you want to put the name of the person you're addressing it to, what their position is, the name of the organization, and then just state, dear like HR. And then you put in an underline exactly what it is you're requesting. So the person's aware of it as soon as they open up your email, request for accommodation based on family status. In this case, as I said, the person had made a verbal accommodation request that went unanswered. So they followed up with this written email saying, several months ago, I made a request for a scheduling change to accommodate my childcare duties. I was advised my schedule could not be changed since I was a new employee. So as just a quick note, the Human Rights Code applies to all people, all employees equally. So it doesn't matter if you're probationary, it doesn't matter if you're new. So the fact that this person's employer told them that they couldn't accommodate them because they were a new employee was actually right there, a breach of their code rights. So moving along, I write now to ask that you reconsider my request for accommodation based on my family status as per the Human Rights Code of Ontario. So unlike the first request I showed you where we didn't even use the word accommodation, in this one, it's a much more formal ask. There's a direct reference to family status, to accommodation, as well as to the Human Rights Code of Ontario. Then the person goes into the who, what, when, where, whys that I was talking about. They state what their situation is. So they're a mother to 3 young children. They list the ages of the children. They list that they're actually a single mother or someone who's solely responsible for their caregiving duties. And then they request, or they state what their situation is. So their situation is that because of COVID and intermittent school closures, this person is having a very hard time securing childcare for their kids before and after school or days when the schools are closed. So on that note, they ask for 3 different types of accommodations. They ask that they're not scheduled for consecutive weekend shifts. And again, one thing Richa mentioned is that you shouldn't expect your preferred form of accommodation. And another thing maybe to be proactive about is try to make your accommodation request reasonable. Maybe it's the case that you are actually unable to work weekends, period. But if you think you do have some ability to work weekends in your job, it may not be a good idea to state right off the bat that I can't work weekends, period. So in this case, the person says, finding childcare on weekends is difficult. So she acknowledges that. She says she doesn't want to be scheduled consecutive weekends, but she does state then that she can work on weekends. So it says, I can work on weekends, but working consecutive weekends is difficult. So be specific about your request and be honest about what your needs actually are. Then she also states that she continued to be scheduled for day shifts because finding childcare in the evening is even more difficult than finding childcare in the day. And then lastly, she requests that she's transferred to a different location that would make managing her childcare duties more manageable. And then she follows up with the same thing that we included in our last email, which is please let me know if you need any additional information. It's always good to include something like that at the bottom if you are making an accommodation request. And then she goes on to add, I'm happy to provide whatever is required. So that goes back to what I was saying before about just, try to strike a positive tone because it's all about that open communication. Okay, and then going to the next slide. So some final words of advice. So just like I showed you in that previous slide, if you are following up on a verbal or written request that was ignored, make sure you refer to it in your initial written request or follow-up email. So, something along the lines of like, further to my request made on November 1st, 2021, I'm writing again, just in case, if things don't go your way, at least you have that record to show that, look, I've tried several times to make this accommodation and it didn't go anywhere. So it's just good to trigger that. And then you also want to do this, especially if your request was made verbally. So the other thing is that many employees will be able to navigate the accommodation process on their own. Especially if your employer is respectful, responsive, if they're sophisticated, they have, an HR department. But sometimes some employers, even those that are sophisticated and have, functional HRs, deliberately ignore their duties under the code. And if you feel that, your employer is one of those employers, don't be afraid to ask for help. You can always try to contact your legal clinic for free summary advice, and we'll give you advice even if you don't, even if you're not eligible for our services generally. And if you are eligible, we may even be able to help you write a letter to your employer. So we can either help you what we call ghostwrite it, where we write it, but you send it, or you may be able to retain us to write a letter directly to your employer. You can also call the Human Rights Legal Support Center. But just as a word of caution, if your accommodation request doesn't pan out, so let's say your employer either refuses to participate in the process with you, which is a failure of their procedural duty to accommodate, or they just refuse to give you any form of accommodation whatsoever. In those cases, again, contact a legal professional for advice, call one of the local legal clinics in your area. You may be advised to start a claim through the Human Rights Tribunal of Ontario in such a case like this. But just as a caveat, although you are entitled to make a claim through the HRTO, it's not always the most practical route, especially if you're currently employed and you're seeking an accommodation that you need. So like a shift change, for example, because of daycare duties. That might be tricky given the kind of delays that the tribunal is currently experiencing, where it can take up to a year before you even get a response in writing that they've received your application. So that, I guess, circles back to what I said originally, which is contact a legal clinic for help. We can definitely at least give you some summary advice on what you may be able to do in your situation. And as a sort of last final word, this process can be intimidating for many of us, but there is a significant mental and physical cost when we don't ask for help. So be proactive. As a last note, I'll give you a personal anecdote. It's not exactly about family status because I wasn't a mother yet, but it's a cautionary tale of what can happen sometimes when you don't ask for help. So when I was a lawyer in training, I worked for a really amazing legal clinic where the lawyers generally worked 10 to 11 hours a day because that's how dedicated they were to their community. I was young, energetic, and super determined to make a good impression. So I made sure I never left the office before any of the senior lawyers. In the normal course of things, working these kinds of long hours would be no big deal, but I was pregnant, and as my pregnancy progressed, it became harder and harder to do those long hours. I barely had enough energy to do my regular shift on most days and then take, the subway and the bus home for another hour after. But I kept wanting to make this really good impression on my bosses. And I also shamefully was not aware of my rights under the Human Rights Code. So I just stayed silent. I didn't speak up. And then at 26 weeks pregnant, I unexpectedly went into labor. And I later learned that one of the triggers for that event was the physical stress on my body due to the kind of hours I was doing. And it wasn't anything that extraordinary, for people working in the legal field, but even working that 40 hours a week was a stress for me that could have avoided, such a traumatic event. So it's good just to keep that in mind, that there are sometimes consequences when we don't speak up. So don't be afraid to speak up. Sometimes the consequences of not speaking are actually worse than speaking and maybe not getting your preferred form of accommodation. Okay, so now I'm going to switch it over to Reggie, who's going to be talking to us a little bit about law reform with respect to family status accommodations.
Thank you, Tisha, and especially for sharing your personal experience. And thank you, Richa. So law reform, Richa, can you switch to the next one? Yeah. So even though the Human Rights Commission and other government policies are providing protection to many vulnerable workers and individuals, there are still some concerns that from community, which are brought to the Human Rights Commission, and they're also working on these issues to improve. For example, the complaint resolution and the human rights, hearings timeline are too long. Another example is applicants and representatives have little control over the complaint process and not enough awareness or education about human rights in the community, especially for people with language issue. And, we see this every day. Each time we go on any sort of a media outreach about this issue, we get hundreds of calls. People don't know what to do in these situations. So the education part is really important. And even for workers who have language barrier and mental health issue, they are more vulnerable to this. So we think that the government should put more money to educate our community so people can learn about their rights and access the tribunal to challenge some of the discrimination and harassment that they may face due to their vulnerability. And the current system does not also address the systemic issue or promote gender equality or indigenous or racialized people rights as well. And this is very clearly outlined how, the certain groups are being left out through the system from the report called Coming Full Cycle Connecting to the Generation, which is written by National Union in 2019. And also the current system not only sort of addressing the systemic issue, but also people feel that even accessing what we have is sometimes it's difficult. For example, the whole process could be very formal and not accessible to people who don't have representation or language issue. These are some of the things that is already have identified from many human rights advocates. Even Human Rights Commission is working on this, and also we see on the ground daily basis. Next slide, please. As a community member, it is important for us to learn about our legal rights and also get involved to make changes to reflect our community need and also to create an inclusive legal system. Some of the way that you could get involved, Human Rights Commission always reach out to community to get feedback to improve the system. So it is important that as a community member, we provide our feedback on racialized profiling, and racialized discrimination of Black people in policing to bring collective impact, because this is one of the area that we see that many Black many individuals from the Black community have been targeted and affected. Another way, in recently, the Human Rights Commission also requested community to participate in public consultation on developing a new policy on discriminatory display of names and words and images that impact Indigenous community. So those are like, for some of the example, how you can get involved. Always look for consultation and how you can give feedback as a community member to create this change. Next, please. Next slide, please. Yeah. Some of the key systemic issues impact women especially. And some are like affordable childcare, pension stability, precarious employment, government policies. For example, employment insurance program failed to support women and low wage and precarious workers. It's the policy that is really, it's more not inclusive. Research shows that these issues are interconnected and have a have a connection to generate generational impact on women. Women and many families from vulnerable community are struggling to find accessible and affordable childcare due to high fees and wait list and poor access to licensed spaces. Furthermore, it is well documented that women workers generally earn less than the male workers who are doing the same work or similar work. It's also known as pay inequality or wage gap or wage inequality. The gender pay gap affects more marginalized women and marginalized workers. Women work in precarious employment as a temporary part-time and freelance and contract without benefit. This is also applied. We see that many of the precarious workers are also come from racialized community. And so one of the reasons women do these sort of work so they can take care of their family, and also due to the inequality in our society, these are the jobs available to women and certain individuals from certain community. And our laws and regulations are not designed to address these systemic issues and protect women and vulnerable workers. Employment insurance will be a good example, for example, again, the research shows that we have seen that many of these vulnerable workers having issue accessing these benefit. In order to apply for EI regular benefit, one of the requirement is you need to have 400 to 700 hours as a new entrance or re-entrance. But now the government, due to pandemic, they have brought down to 420 hours requirement, which is temporary. But does this mean to many women? And what does this mean to many precarious workers who are doing temp agency work and contract workers? This means many of them won't have access to this EI benefit because they may not qualify and will not meet the requirement. And another reason is, the EI claim only will, normally pays 55%. of their income. Again, due to pandemic days, was some changes earlier, but again, right now is 55%. Again, what does this mean to these vulnerable workers? It's think about women who are working part-time job, or workers who are working through temp agency as a part-time or contract workers. These workers, I have seen people are getting only $50 a week as an EI income. So this affects the certain communities a lot. This is one of the reasons our regulation and the law need to be changed to reflect the community needs, reflect what we need in our society, and in order to create an inclusive society. Next slide, please. And for example, Community Legal Clinic, EI working group, have working on this issue for years with the government and policymakers and other advocates. And we are advocating for better policy change, the policy that include all workers equally, and also the policy that actually allow these more vulnerable workers to access EI. So these are some of the recommendations. And for example, establishing a universal eligibility household to 360 hours week or 12 weeks of work. That means, people should be able to access long as they have 360 hours of work or employment hours in the past 52 weeks. And also eliminating quit and fired disqualification rule. This affects many workers. When there is a discrimination and harassment, many times we have seen that, and people have left their job due to protect their health. But EI, it's you could really explain, but when you don't have a representative or lawyer or legal worker, it's hard for individual workers to argue. So that whole requirement need to be removed. And then you could actually sort of see all other recommendation here. One of the other recommendations that will really help these workers is bringing at least minimum benefit flow of $500. So it's nobody should survive on $50 a week. And this is one of the example, but there are a lot of other regulation and even human rights code need to be reviewed and changed in a way that we could accommodate and address the community needs. And I will, we will send this PowerPoint. You could actually read through some of the recommendations, but we have putting forward and working on it. Thank you. Now I will pass forward to Richa, and I think we will also have a question and answer period, which will be not recorded.
All right, thank you, Reggie. Thank you, Tisha. So, that concludes the substantive portion of our presentation. I hope you have enjoyed it and learned a lot in the last hour or so about your rights and about how family status works and sort of how to apply your rights and the ways in which you can get involved in areas that affect family status rights. So we're going to open up the floor to questions